The difference between a will and a trust is that a will must be taken through probate before the assets can be distributed to the beneficiaries. With a trust, the person that you've selected to make those distributions doesn't need to wait to get a judge's approval. Both the will and a trust will set forth beneficiaries and the plan for the distributions to be made. However, the will, because it has to go through probate, will cost an additional 2 to 5% of the market value of the assets. Well, probate is the court-supervised process by which assets are transferred from one generation to the next. Before distributions can be made, the assets have to be inventoried and appraised, public notice has to be given, and a judge has to have a final okay before any distributions can be made. This process is going to take at least 6 to 9 months and is going to cost anywhere between 2 and 5% of the market value of the estates. For an estate valued at $500,000, you're looking at fees anywhere between $10,000 and $25,000. Of course you can. As the person setting up your trust, you get to decide how and when those assets are going to be distributed. Now, in the case of minor kids, what we typically set up is while the kids are still under 18, the assets can be used for their health care, education, and other sort of maintenance costs. Then, when they turn 21 or 25, they might get some amount of their share, say a third, and another third can be given to them when they're 30 or 35. And the final share may be given to them when they're 30, 35, or maybe your kid, 75. You get the idea. You get to decide how and when your kids are going to get the assets. Well, our living trust comprehensive packages include the trust, wills, powers of attorney for financial affairs, advanced healthcare directives, as well as additional documents to properly fund your trust, such as a certificate of trust to transfer bank accounts into the trust. We also prepare up to 2 deeds of property in California to transfer into the trust. If necessary, we can prepare additional funding documents such as out-of-state deeds or other sort of assignment documents for business interests. In addition, you also get this estate organizer, which will include copies of your documents, plus some additional information that can be used as a resource in case you or your family members ever need it. The additional cost for changing your documents is usually nothing. Most of the changes that people need to make are what I call name changes. That means changing the name of a successor trustee. That's the person that's going to be taking care of your trust after you and your spouse, if you're married, are gone. In those cases, we're not going to charge you anything. Only if a major change occurs, a marriage, a divorce, or if your assets grow such that it's going to require some additional estate planning work to deal with estate taxes. Otherwise, there isn't going to be any fee for those simple, small name changes. Yes, absolutely. We want to make sure that all your extended family is properly protected. Therefore, we honor the CSFA and any other association discounts to all your immediate family members. That includes your parents, adult children, and siblings. No. There are some advertisements out there for a supposed product that shields your assets from creditors. However, the trust that we're creating for you is a revocable trust. And while you're alive, while you completely control the assets, you're not able to shield that from creditors. This product is designed to avoid probate and to ensure that your assets are properly set up for an easy transition to your spouse if you're married and to your kids. But creditors are still going to be able to reach your assets since you're going to continue to have complete control of them. Life insurance is an important component of your estate plan, especially if you have minor children that are going to need money and cash especially to be able to take care of them through their childhood. However, in many cases, there isn't any additional things that need to be done with respect to your life insurance policies. We will look at the total amounts of death benefit to ensure that your kids have the adequate funds necessary to take care of them. However, the only thing that might need to be changed would be the beneficiary designations to make sure that your overall plan is tied in together with the life insurance. As an example, you don't want to have $1 million life insurance policy that pays out to your 2 kids as soon as they're 18, giving them $500,000 at that age if your trust and the overall plan that you're trying to set up sets forth a plan of distribution that gives them access to some money but doesn't give them a full payout until they're 25 or 30 or older. So we want to make sure that the life insurance is tied in with the rest of the living trust and the other estate planning documents. Well, we're not financial planners, but we are very familiar with investment accounts such as 401ks and IRAs, and we're very, very familiar with retirement and pension plans such as CalPERS. In all those cases, any tax-preferred accounts or retirement benefit plans, will probably need to stay in your name alone instead of being transferred directly into the trust. However, it will be an important part of what we do to talk about and think about what the implications are as far as the beneficiary designations and who's going to be getting any assets that may be coming to you or your beneficiaries if you pass away. So again, all of this is part of an overall comprehensive estate plan. In most cases, there's nothing that needs to be done with your retirement plans, but it is part of the discussion that we'll need to have when we're setting up all your documents. If you have a special needs child, the most important thing you need to do is make sure that we talk about and you select a guardian that's going to be able to take care of that child like you've been able to take care of him or her for their whole lives. Just as important is to put into your living trust a special needs trust provision so that the share of the estate that's going to go to that child is going to be set aside in such a way that it's not going to jeopardize their ability to continue to receive or to get in the future state and federal money or aid that may be coming to them because of their disabilities. This can be put into the living trust. It doesn't require an additional trust, and it's included as part of our basic living trust package. In one word, it's confidence. The products that we provide to you should instill you the confidence that they're going to work. We don't put any disclaimers to what we do, unlike the online services or paralegal services out there that clearly disclaim the fact that they're not attorneys. Well, we are attorneys, and we stand by the documents that we produce, the advice that we give you, and at the end of the day, the estate plan that you have will work. A durable power of attorney and a healthcare directive basically is going to name somebody to make decisions for you if you're incapacitated or can't make those decisions for yourself. The durable power of attorney for financial affairs will encompass all things legal and financial. So things like closing a real estate deal or opening or closing a bank account. The Advanced Healthcare Directive is going to deal exclusively with medical decisions. So if you have surgery or in a car accident and a decision has to be made about the type of care that you're going to be given, what you're doing with the Healthcare Directive is naming the person that you want to be able to make that ultimate decision. A lot of problems arise in this type of situation when there is no Healthcare Directive and the spouse, the children, the parents have different ideas and conceptions about what the healthcare decisions should be made. With the Healthcare Directive, you've decided who is going to be the one that's making the final decision, and it eliminates a lot of the bickering and infighting that can arise in that kind of situation. If you own real estate outside the state of California and you pass away, that piece of property is going to have to go through probate in the state where it's located. That can be inconvenient at best and very expensive and time-consuming at worst. What you want to do is you want to make sure that that property is properly funded into your living trust so that when you pass away, the person that you've named to take over the control of the trust, your successor trustee, will be able to go to that other state and transfer that property or sell it without having to go through probate. This is going to save your estate a lot of money, a lot of time, and a lot of heartache. Absolutely. As part of our estate planning practice, we provide a free consultation to brand new clients with no estate plan and also to people that have an estate plan already in place. Whether you've set up a trust or will in the last few years or decades ago, we will review the documents, have a free consultation with you where we review everything that's in there, advise you on any changes that you might consider making, and then typically the changes that need to be made, if they need to be made at all, are usually very minimal.